I'm Helen Cogan, and thank you for joining us. I'm the Managing Director of Cogan Page, and we're a proud member of the IPG and a beneficiary of the PLS as well. And I happen to be a board member of both organisations. And for anyone who doesn't know the IPG, which I can't believe, it's a membership body that supports over 600 members in the world of independent publishing with resources, events and services. And I'm going to, at the end of this, I'll tell you a little bit about some of the stuff that's coming up, which is really interesting and really exciting. So this session, of course, is about generative AI, the hot topic for everyone in publishing at the moment, with some enormous implications for copyright, which is the bedrock of our activities. And over the next 30 minutes or so, we're going to take a look at the latest issues, opportunities and risks around AI throughout the legal life cycle of our content, and get an idea of what publishers need to be thinking about in response. And I don't know about you, but there are some very significant challenges that certainly, we're dealing with at Cogan Page, and I'm sure everybody sitting in this room are sort of trying to think through it at the moment. Which is perfect because we have leading the session Mary Elliott, who's managing partner at the business law firm Fox Williams and head of its publishing and digital media sector group. She's advised many companies and institutions on a wide range of legal issues, including transactions, joint ventures, corporate restructures, and venture capital and private equity fundraisings. Importantly for us today, she's also a top expert in publishing copyright and rights, and is very attuned to AI's impact in this area. And even more important than that, it's Mary's birthday today. We won't ask you to sing happy birthday, but we know you mean it, really. And we're very grateful she's taken herself away from her celebrations and the general election. So happy birthday, and over to you, Mary.
Thank you, Helen. I'm sorry, can everyone hear me? Yeah? Excellent. Helen and I have actually done this dance a couple of times, and over the last 18 months or so, since I've started talking about AI and publishing, I've certainly seen the music change. There's a difference in atmosphere. I'd say 18 months ago, what on earth is generative AI? What is ChatGPT? That very quickly moved on to the concerns around content, about copyright, about infringement. And that's still there. But there then was a move to, well, what can AI do for publishers? How can you embrace it? And I'd say recently, particularly the first half of this year, we've increasingly seen AI licensing deals start to come to fruition. Copyright's still at the heart of the main concerns. But what I try and tell my clients is this environment is shifting. Everything about AI is still new. It's bringing up new issues. The considerations change pretty much day to day. And what I want to get across to you today is the ability for you to manage that. And the way, it might sound very boringly, for you to manage that is through your contracts. You've got the tools to navigate this uncertainty ahead. So today I just want to touch briefly upon copyright and AI and where we are legally. And unfortunately, I can't promise you a silver bullet. There's still a lot of uncertainty. I'm then going to run you through what I term the legal life cycle of publishing. And this is about the content journey from acquisition to product creation to marketing and publicity. And that's the bedrock of a workshop that I'm building with the IPG, where if you're interested, I'll be taking you contract by contract through different clauses and provisions that you can use to really frame your approach to AI. So, copyright. The million-dollar question for IP lawyers really is, does AI-generated work attract copyright protection? Now, I feel like I'm probably teaching my grandmother to suck eggs, and while Helen has proudly said I'm an expert in copyright, I do approach publishing from a corporate background. And so my approach is more about the holistic aspects of publishing. So apologies if I'm teaching you things you already know. But as a reminder, copyright attaches to literary works and artistic works created by a human that's original. And by originality, we mean it's got to result from an author's skill, labour, or judgment, and there's got to be a degree of creativity and intellectual effort. Now, I say degree, it can be minimal. We all know that copyright doesn't necessarily attach to good pieces of work. But it does need to be independent, and it can't be copied from any other protected materials. But interestingly, the UK is one of a very small handful of countries that does recognise copyright and computer-generated works. Now, people kind of immediately jump to this and think, oh, maybe that is AI. Now, computer-generated works was brought into the legislation in the 1980s, and as a lawyer, we don't think that far ahead. I'm pretty sure the legislation didn't envisage AI. What we're talking about with computer-generated works is it's still got to be original, but the originality is about the arrangements that are being put in place for the computer to generate the work. We're not talking about a work being created with computer assistance. And here, if we can find that originality in the arrangements, it is the person who created those arrangements. Trying to apply this to AI isn't going to work, because who is that creator? Is it the AI coder? Is it the person who sets the parameters? Is it the person who puts in the inputs? Is it the person who created the data for training? The way that the law's going, this is not going to be the answer to AI. Why does any of this matter? Well, as I'm sure all of you know, copyright in literary and artistic works lasts for 70 years from the year of death of the author. Now, for computer-generated works, it's only 50 years from creation. So we're already talking about a much smaller period of time at which you can monetize the rights you have. But the really important thing is, if we don't think copyright can attach to AI-generated work, it is not copyrighted, it is not protected. So if you are using AI-generated materials, anyone can use them. So it's just kind of putting that into context. Having said all of that, I'm not sure that's the question we're really interested in today. It's the one lawyers salivate over, they philosophize about it, it's what gets certain IP lawyers out of bed in the morning. But let's be honest, we care about infringement. And the question, is the training of LLMs, generative AI platforms, breaching your copyright? So talking about infringement briefly, you have two types of infringement. You've got primary infringement, and that is your basic copying. That is the copying of the whole or substantial part of the work, directly or indirectly, and the indirectly there is about instructing somebody, authorizing somebody else to make that copy. Secondary infringement is much more about commercially dealing with a copyrighted item. You're selling, you're possessing, you're exhibiting a protected item, and there's a knowledge qualifier there. You know or have reason to believe it's infringing copy. I'm not going to go through the exemptions or the permitted acts. Those are things like pastiche. The US has fair dealing. But suffice to say, going back to the main question, does the training of LLMs infringe the copyright of content creators? Ultimately, yes. Let's be honest about it. There are certainly infringement actions happening. And indeed, OpenAI, the creator of ChatGPT, said, given that copyright covers virtually every sort of human expression, blog posts, photos, everything that's out there, they admit that it would be impossible to train today's AI models without using copyrighted material. Now, they're not saying they have permission to use that material or they don't, but it's an open admission that this is what is happening. The other question I think gets looked upon less is this question of, do large language model outputs infringe the copyright of content creators? Now, the risk of this, I have to say, is relatively low. What we're talking about here are AI models that have been trained on a huge data set. And what are the chances they're going to regurgitate an exact copy of something? It might be unlikely, but the message I want to get across is AI increases risk. That is the point, and that is what we need to try and protect. Turning to where we are with the law, and apologies, I have used AI-generated images because I just thought it was fun. So on the left, we have something that symbolizes the speed of legislation, and on the right, we have AI. Where are we? So the UK government in 22-23 was all over AI. It was the buzzword, and they were engaging with copyright, and they promised a code of practice about AI and copyright for the summer of 23. Didn't come. And earlier this year, the IPO admitted there's a bit of a stalemate. No one is really engaging with it, not least because we now have election day and everything has been delayed. I think everyone was delighted to see that nearly all the major party manifestos did touch upon copyright and AI, but I'm not going to hold my breath. We are entering into the summer recess, I hope, whichever government does kind of not go on holiday and start doing some urgent action. But it's not a priority at the moment. And even if it was, it takes years for these legislations to come through and then to be enforced. It has been a great surprise to see how quickly the EU AI Act came into force earlier this year. And we should start to see impacts of that in the coming years. And the great joy about the EU, despite Brexit, is our day-to-day lives are impacted about what they do. So things like transparency. The EU AI Act requires these large language models to identify and disclose their data sets. Hopefully that will start to come through. But, might be biased here, EU legislation isn't the most detailed. They tend to be very high-level guidelines. They lack definitions. So we certainly don't have the answers yet. And that's because all legislation needs to be enforced in court, really, to understand what it means. So we have a huge number of cases going through the systems at the moment. I've labelled a couple of them up there. But we're months and still years away from knowing what the answers will be. And even when we do have the answers, I will caution against excitement that we'll have any kind of certainty, because the nuances of the legal cases being thrown are ridiculous. And so I'm expecting all these cases to really turn on their facts. And one of the reasons that so much is being thrown into the legal argument is these platforms know they have infringed. That is part of the problem we have. So what can you do about that? Everyone talks about it kind of being a wild west out there, and as I've said, there is regulation. We need to see how it falls out. But you do have the power to regulate what AI means to you and what it means to your authors and your content. And you can do that through the legal nexus. So if we start with content creation, content acquisition, let's start with an author contract. What I would encourage you to do is start to use your contracts to form the basis of a conversation with your authors. Too often, I know, author contracts come out and you agree the title, you agree the length, you agree the delivery, and you agree the royalties, and then it disappears into a drawer. In the past, I would have said that's fantastic. The last thing you want to do is rely on your contracts, because then your relationship has fallen down. But now I want you to pull out that author contract and look at what protections you have and what protections you might want. Do you want your authors to be able to use AI? If not, get them to warrant that they haven't. Now, that was an approach I was seeing a lot about, but let's be honest, people are using AI. So what I'm seeing now is people saying, okay, if you use AI, please can you disclose to me how you're using it? What is the impact on your work? And get them to warrant that. You also need to think about, well, what permission do I need from the author to exercise the rights potentially using AI? Build that into the contract. And one of the ones I'm seeing a lot at the moment is your standard rights of removal, amendments, your kind of editorial rights within the author contract. You need to make sure that works for anything that's AI generated. Do you need to suddenly pull out an illustration? Do you need to suddenly rewrite something? So just have a look at those clauses. When it comes to acquiring rights, what I think will be more important is your due diligence on the head contract. We are now seeing really quite bespoke clauses coming into author contracts, largely because of agents, but also very passionate authors who are trying to put blanket bans on the use of AI. If you've got one of those in the contracts, you're going to have problems licensing out to anyone who wants to be able to use AI. So you've got to follow it through. And if you're acquiring rights, look at the head contract would be my advice. So let's talk about outward licensing a little bit more, and I will touch upon AI licensing in particular. But you've got to think more carefully about what you're licensing. What are you permitting your licensees to do? What are the limitations you want to set? Do you want them to be able to use AI translator tools? Do you not want them to use them? If it's not in there, chances are they can. So you need to really start building things in. You also need to think about, again, your head contract says and make sure it flows through. But in the last few months, I have seen an increasing number of the large tech platforms sending out their AI licenses to publishers. And I'm sure there are some people in the room who have received some. And the first draft of these are incredibly broad. They effectively say, well, you're giving us a non-exclusive right to do whatever we like with your content in our AI, save for producing a full verbatim text. And I look at that, I'm like, crikey, so they could produce 90%? I mean, they are really that broad, and they're pulling a fast one, they're giving it a go. So if you do have one of these, and you're thinking about it, please, please do get proper legal advice. But as a tip to the things that you should be thinking about, I've tried to shorthand a kind of guide there to why, what, who, and when. So why are you thinking about doing this? Now, I say that because we are seeing some really large licensing deals going through. With the big aggregators of content, we're talking about hundreds of millions. Now, they are doing that, and I might be cynical, but the AI platforms are doing that as a quasi-settlement. They are doing that because they know they've been using this content. So to a certain degree, these licensing is compensation. It's a bulk payment. But what does that look like going forward? Do you want recurring revenue? Can you get recurring revenue out of that? So really go into it thinking, what is the long-term rights I want to use with this content? There's then the what. What are they going to use it for? Are they only going to use it for training? Can you put blocks on it that says it can't form part of the output? So again, just thinking about what is the risk here. Also, with the what, can you audit it? Now, we let our authors come in and audit our royalties. No reason why you can't ask to have the right to audit. Now, I would say AI platforms use their kind of opaqueness, the unbelievably complicated coding to kind of scare people until you wouldn't understand. We don't know how it works, you won't understand. Ask the question. I would say one of the most powerful tools we have at the moment is ignorance. And that you can just say, well, could you explain it to me? Tell me how my content's going to be used. Okay, if that's the case, could you write that in the contract, please, and underpin it? So have that conversation. Then we've got the who. Attribution is becoming increasingly important. And we are seeing, thanks to these large deals, if you go onto ChatGPT now, you do quite often have a link back to the underlying news article, or at least the publisher. And that is a great opportunity because you are getting your client, your audience back to your website. So you should be insisting that any of your content that is used in an output is attributed. And we'll talk about author attribution in a moment. And then finally, the when. And by that, I mean, when does it come to an end? Does it ever? I mean, I do have to caution you. I do think once your content is in one of these things, it's never coming out. But that doesn't stop you from asking the question. What happens if they breach their license? What happens if they don't pay you? What are your rights? We don't know, but have the conversation. Don't be afraid to ask these questions. Product creation. There are just 3 points I want to cover off here. I want to touch upon the kind of slightly difficult area of authors' moral rights. And there are 2 key ones that I think are important for AI. One is the right for them to object to derogatory treatment, and the other one is this right of attribution. And my question is, could an author complain, enforce their moral rights to the amendment, adaptation, or illustration of their work by generative AI? Could it prejudice their reputation? Now, I'm not sure, but I wouldn't put it past some authors or agents to start saying that. So again, I would be encouraging you to get waivers of moral rights for the things you know you're going to be doing. Be transparent, get the buy-in from the authors. On the right of attribution, again, that feeds back to that licensing point. You might, as publisher, want to be attributed, but there's also the moral right for your author to be attributed. So make sure that's in there. Errors and omissions. I'm hopeful that anyone who is using generative AI is checking it as a human. Certainly, things still hallucinate regularly. I think if you are engaging with an AI tool, if you've actually contracted and brought one in-house, you might have a walled garden, you want to be looking at your terms and conditions. Who is liable for the errors made? Are they putting it back on you to check? Or if they make an error, do you have recourse? The other thing I'd be wary of with some of the AI providers out there, they are all rapidly growing startup companies. Not many of them are profit-making yet. Are they good for the remedy if there is a liability? Also, if you are working with an illustrator, an author who is using generative AI, how are they verifying that's not a copyright infringement? What are they doing? So again, you can build that into the contract with them, asking them to verify and check. Finally, confidentiality and data security. Even your walled garden approach will have a back door. Be very mindful of what you are putting into these systems, regardless if they've been built for you or not. You should certainly have an AI policy for your employees. What can they put in? What can't they put in? I wouldn't be afraid of, extending that to your freelancers and authors as well. What happens if, yes, you've promised your author you're not going to use generative AI, but then they upload their book, to a platform? So have these conversations. Finally, on this bit, content protection. I know there's a very good session after this that deals with the really exciting stuff. Obviously, AI has increased the risks of infringement. We've talked about that. But it's also increased the risk of piracy. It's made it much easier. It's much easier to bypass DRMs as well now. You just have to think of a bad actor using an AI machine to continually hack away at something. So everything has become more risky. But it's not all doom and gloom. AI can also help you protect, and it can do better searches for infringement. We talked about terms and conditions and contracts. Also, fight back, make it clear what you want your content to be used for. Put no AI training notices on your content. Put it on your website. Again, OpenAI has said it is for publishers to opt out from their web crawler, which is a horrible word for them, their scraping machine. So make sure your position is clear on your website and on your content. And don't be afraid to tell the big AI providers, this is your position. You can send them cease and desist letters. If you have any suspicion, or even none, make it clear, write to them. Have that record of your position, because we don't know yet where the law's going to fall out. And there is talk about it being an opt-out issue. So start your record keeping now. Finally, you've got your product, you're going to go to market. Now, that's just a whole host of kind of codes that you could trip if you missell or misrepresent your book. I'm talking there about not owning the fact that it's got AI generation. Now, I kind of think, well, what's the risk here? Is anyone really going to suffer loss? The risk is obviously reputational. We all know some publishers, some literary festivals that have, fallen over themselves a little bit by using particularly generative AI illustrations. But what I'm getting at here is you need to know what your product is. And the way that you know that is by going through that contract, all those contracts, understanding the supply chain that you go through and where AI plays into each and every one of those. That's the end of the life cycle. Just finally, I did want to reassure people, AI is impacting all businesses. It's impacting law dramatically. I do think it's slowed down a little bit. I think that kind of rapid growth and rapid excitement has tapered off a little bit. I think there are some statistics saying, most people have now played with ChatGPT. A lot of people have stopped. So I think we're in this kind of era where we've got a little bit of breathing space. I expect it will ramp up again. But I've got a partner at work who continually goes on about AI being the new email and the new internet, and it's going to change everything. What I see that meaning for publishing, and I say that as an outsider point of view, is that flood of content. Now, at the moment, probably not great content, but it's going to become much quicker and much more rapid to get things out into the market. So what's your competitive differentiator going to be? Can I just point out AI misspelling, by the way, not mine on those images? But how are you going to stand out? Once you've determined that, who knows what it is? It could be brand, it could be human voice, or anything you think of. How are you going to protect it? And until the legislation and those court cases come through, I say you need to protect it through open communication with your counterparties through your contracts. Thank you.
Thank you very much. Thank you.